Our next item for consideration is 9594, the Protecting Taxpayers' Wallet Act. The clerk will please designate the bill.
H.R. 9594, the Protecting Taxpayers' Wallet Act, a bill to amend Chapter 71 of Title V, United States Code, to charge labor organizations for the agency resources and employee time used by such labor organizations and for other purposes.
Without objection, the bill should be considered as read and open for amendment at any point. Without objection, to ordered. Chair recognizes himself to offer an amendment in the nature of a substitute. The clerk please designate the amendment.
An amendment in the nature of a substitute to H.R. 9594 is offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for purposes of further amendment. I now recognize myself for 5 minutes for a statement on the bill and the amendment. H.R. 9594, the Protecting Taxpayers' Wallets Act, would charge federal employee unions a fee to compensate federal agencies and the nation's taxpayers for resources used to support union activities. Under federal law, certain federal employees are authorized official time for collective bargaining purposes during the time the employee otherwise would be in a duty status. In other words, federal agency employees who also serve as employees of a federal employee union may conduct and be paid to conduct official union activities when they would otherwise be performing their regular job duties. This bill would shift the financial burden of supporting such official time away from the taxpayers to the federal employee union organizations. It would shock American taxpayers that federal employees are being paid to work substantial hours in support of public sector unions instead of the agency operations, missions, and programs they were hired for in the first place. In some notable cases, federal employees dedicate all their working hours to union activities. This bill would discourage overuse and abuse of official time by federal employees and help restore a healthy balance to employees' time. I want to thank my colleague, Congressman Scott Perry from Pennsylvania, for his attention to this matter and for leading the Protecting Taxpayers' Wallet Act. I urge my colleagues to support this sensible reform. I now yield to Ranking Member Raskin.
Thank you very much, Mr. Chairman. I see this bill as union busting. The bill's deceptive title masks its true purpose to attack and eliminate unions that represent federal government workers. And there are hundreds of thousands of them. In the process, the Protecting Taxpayers' Wallets Act accomplishes the opposite of its explicitly stated policy goal. The bill would redefine what is known as official time, or time spent representing employees in grievance hearings and negotiating collective bargaining agreements, as personal time. It would require federal agencies to charge public sector unions a fee when they use office space and parking spaces or incur other expenses for what the authors are calling non-agency business. Even more egregiously, the bill would allow an agency to unilaterally decertify a legally formed public sector union if it refused to pay fees imposed by this bill. This, to me, is standard issue anti-union, anti-worker propaganda, which flies in the face of 46 years of federal law and practice. In an overwhelmingly bipartisan vote, Congress passed the Civil Service Reform Act of 1978, which specifically codified the concept of official time. The Senate report that accompanied the law stated that official time is of, quote, mutual interest to both the agency and the labor organization. Part of that law's original purpose was that a recognized federal employee union was required to represent both all union members and all non-union employees who benefit from the union. So federal unions represent all federal employees at their designated agencies, playing an essential role in the governance of a successful workplace. This bill would deprive all federal employees of representation before their agency on the terms that have governed for the last half-century. The law is clear about when a union leader's duties qualify for official time and when they do not, ensuring that use of official time is indeed official, necessary, and in the public interest. Official time can be used only for representational activities like creating fair promotion procedures, establishing efficient and flexible work hours, setting procedures that protect employees from on-the-job injuries and risks, enforcing protections against unlawful discrimination, developing telework practices, providing workers with a voice in determining work conditions and representing employees in grievance and disciplinary actions. It cannot be used for internal union business. Contrary to what the majority argues today, official time actually saves taxpayers money because it provides agency officials and union leaders with a far less expensive and formal way to negotiate agreements outside of time-consuming administrative processes or expensive legal engagement and court appearances. It's preposterous to authorize an agency to terminate the certification of a labor organization. It's the workers, not the agency, who get to choose who represents them and how. No agency should have unilateral authority to decertify the unions that represent the workers. Again, this bill's a wolf in sheep's clothing. It is wasteful public sector union busting disguised as fiscal restraint. I oppose it in the strongest of terms, and I encourage all my colleagues who support unions and working people to do the same. Thank you for the time, Mr. Chairman. I yield back to you.
Chair now recognizes the distinguished sponsor of the bill, the gentleman from Pennsylvania, Mr. Perry.
Thank you, Mr. Chairman. Before I start the comments on the bill, I ask unanimous consent to enter a letter of support for the Protecting Taxpayers' Wallet Act into the record. The following organizations have signed onto the letter: Americans for Prosperity, Americans for Tax Reform, Club for Growth, Institute for the American Worker, National Taxpayers Union, and Open Competition Center.
Without objection, ordered.
Thank you, Mr. Chairman. And thanks to you and your staff for working with us to include this bill in today's markup. This bill remedies a long-standing injustice: taxpayers bearing the financial burden of federal employees being paid to conduct union activities when they would otherwise be performing their job responsibility as public servants, what they were hired to do. Put another way, when we pay VA employees to care for our veterans or Social Security caseworkers to process claims, we expect them to be doing that work. We expect a nurse at the VA to be doing a job of a nurse and dealing with the VA patients there, not spending 100% of their time working on behalf of their bargaining unit. And we're not saying that bargaining unit activities shouldn't occur, but we're saying that that time should be compensated because you're not doing the work that you were actually hired for. Now, instead, as reports going back years have shown, federal agencies have shown a disturbing pattern of abusing or overusing official time. According to a January 2017 GAO report, 346 Veteran Affairs employees spent 100% of their time doing union activities while being paid by the federal government to do VA activities. Now, it's not Perry saying that. It's certainly not Chairman Comer saying that. That's the Government Accountability Office report. I don't know if my friends on the other side of the aisle dispute that, but that's what they say. Now, while the Biden administration has unfortunately ceased regular reporting on government-wide use of taxpayer-funded union time, information that agencies have provided paints a bleak picture. So we don't have anything that the Biden administration has stopped the reporting, but in FY 2023, the Social Security Administration paid 14 employees over $1.4 million not to process claims or do work for our nation's seniors, but for union activity. This at a time when the vast majority of the buildings that we surveyed in town here, on another committee I sit on, the headquarters of those buildings have occupancy rates in the single digits. These people aren't even many times present for work at the location where we're paying for the building, and at best some of them in the low teens. It's unacceptable to the American taxpayer. Meanwhile, my friends say, well, it saves us money. Well, I don't know how much money it's saving us. Last count that I saw, we're about ready to go over the threshold of $36 trillion in debt. Every 100 days, another $1 trillion. Not saving much money here. The bill would not only require labor organizations to consistently and accurately record the use of union time and agency resources provided for union use, but it requires the head of each agency to charge for the value of said time and resources. The American taxpayers, look, who's their advocate? I get that the union's there to advocate for the employees, but in the negotiation, the person on the other side of the table has nothing to lose because the taxpayers are the ones that foot the bill. They're not at the table. Their voice isn't heard. Again, this bill does not disallow the use of official time. Official time can still be used for the express purpose that it is currently used for. It merely requires labor unions to compensate the taxpayers for the work that they're not getting. The job description doesn't say, when you get hired at the VA or the Social Security Administration, the job description doesn't say official union representative. It says caseworker, it says nurse, it says doctor, it says whatever. But that's not the job that's being performed. And after all, it's the taxpayers who are losing out on the services and resources that they're paying for other purposes. And to my good friend, I'll just close with this. Just because that's the way it's always been done for the last 50 years doesn't mean we shouldn't take a look, and it doesn't mean that it couldn't be done better. And I think it can be done better, which is the purpose of this legislation. I urge adoption. I yield the balance. So thanks the chairman.
Gentleman yields back. Any other members seek recognition?
I seek recognition, Mr. Chairman, to introduce a statement from the American Federation of Government Employees, the AFL-CIO.
Without objection, so ordered.
Thank you.
Seeing no other members seeking. Oh, Mr. Chair recognizes Mr. Biggs.
Thank you, Mr. Chairman. I move to strike the last word. And I would ask that Mr. Perry if he'd engage in just a brief colloquy with me.
Yes, sir, Mr. Biggs.
Because I just want to clarify, did you say 346 individuals in the Veterans Administration spent their entire year, their entire work period, working for the union?
I didn't say that. That's what the 2017 GAO report said.
But I mean, they came into work and they didn't do anything on casework or anything like that. So if
That's according to the report. That's correct.
they just advocated for union positions.
That's correct.
So for the past 3 fiscal years, at the National Nuclear Regulatory Commission, my understanding is that there was 2 employees that also used just 100% of their official time doing union work. Do you know about that?
I'm unfamiliar, but I'll take your word for it.
Well, did you know that they were paid their full salaries to do absolutely no work that they were hired to do at NRC? That's
Consistent with the rest of the reports that we've gotten from agencies and organizations like the GAO.
And that the government, in other words, the taxpayer, in fiscal year 2023, those employees earned between $165,000 and $169,000 a year. Did you know that?
Well, I assume that is the salary for those positions, right? So they would receive the salary for the position they were hired for and then conduct none of the activities for which they were hired because they were conducting these other activities.
It's astounding to me that that's going on. If they're going to do union activities, they should be paid by the union dues, perchance. Just thinking. Further, 36 NRC employees also used some amount of official time doing union work, getting paid by the taxpayer. You know, Mr. Chairman, I'm astonished that there's any opposition to this bill at all. And thank you for bringing it, Mr. Perry, and I'll yield back, Mr. Chairman.
Gentleman yields back. Chair recognizes Ms. Stansberry from New Mexico.
Thank you, Mr. Chairman. I actually want to just say on the note of discussing unions that we are union strong in my office and so many offices across the Democratic caucus because our unions protect the rights of our workers. They ensure fair pay, safe working conditions, and ensure that the workers, whether they're federal workers or in any other industry, have every opportunity to make a fair living wage and to care for their families. But I do want to take this opportunity to say thank you to the chairman and to the ranking member to help advance the amendment that passed earlier in this committee this morning on a bipartisan basis to help address the fentanyl supply chain, which we know is just devastating our communities. I especially am so grateful for the bipartisan support that this amendment garnered here in the committee, and just want to say that when we work together, we can and we will tackle the biggest challenges that are impacting our communities. And on a personal note, I've shared here in this committee previously that the issue of the fentanyl crisis is deeply personal for me. I will never forget the morning several years ago when I received my first phone call that a loved one had died suddenly of a fentanyl overdose. I was actually sitting on the House floor in the New Mexico State House of Representatives shortly after I had been elected, and since that time, there have been other calls. In New Mexico and all across this country, whether it's in Albuquerque or rural communities across New Mexico, countless families are experiencing the devastating losses from the opioid and fentanyl crisis. And far too many examples we have of loved ones who've been lost because of tablets and counterfeit pills that they're buying on the street for just a few pennies, a few dollars, from drug traffickers and suppliers who are adapting rapidly to an economy that is killing our communities. They are pouring fentanyl into the streets of our communities, and that is why we have to fight back on a bipartisan basis to focus on the global criminal networks and suppliers of illicit drugs who are bringing these drugs into our communities and who are counterfeiting pill manufacturing across the country. And today, we did just that by coming together on a bipartisan basis to empower the ONDCP to target the fentanyl supply chain and to stop the prevalence of fentanyl coming into our communities. So I say thank you to my colleagues for supporting this amendment, and with that, I yield back.
Yes, would the gentlelady yield?
I yield to the ranking member.
I want to commend the gentlelady from New Mexico for her excellent leadership on the fentanyl crisis and on cracking down on these pill-making operations. I did want to respond to my colleagues about H.R. 9594, the so-called Protecting Taxpayers' Wallets Act. They are really challenging a central premise of labor management law that goes back more than a half century in America, both in the public and the private sector. The way that private collective bargaining agreements work is that if there are shop stewards who work to pursue grievances or collective bargaining agreements or to help manage the workplace, they continue to be paid under their previous salaries. There's nothing remotely extraordinary or strange about that at all. And so what they're really attacking, of course, is the whole idea of having labor unions. And we understand labor unions are under attack at a time when labor unions are more popular than they've been in decades because of the tremendous economic inequality in the country, where you get people at the top of the income and wealth ladder who are taking vastly disproportionate shares of economic gains, and it's employees and workers who need unions to try to claim a place in the middle class. And so this really is an assault on unions and on middle-class economics, and I'm happy to yield back to the gentlelady.
Thank you to the ranking member. You know, as a former federal employee and as a former federal employee that was in an exempted class that had tried to previously unionize, I want to talk about just for a moment and to emphasize what the ranking member just said, that protections for all federal workers are critical because otherwise they get exploited just like all workers. They get expected to work nights, weekends, to do dangerous things and compromising things that they wouldn't otherwise find within their values or the requirements of their job to do. And so protection of federal workers is just as important as it is for all workers, and I appreciate the ranking member pointing that out. Thank you. I yield back.
Time's expired. Does any other member seek recognition on the Perry bill? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it. The amendment is agreed to. The question is now unfavorably reporting H.R. 9594 as amended. All those in favor signify by saying aye. All those opposed signify by saying no. For what purpose does the gentleman from Arizona seek recognition?
Request a roll call, please.
A recorded vote is ordered. As previously announced, further proceedings on the question will be postponed. Our next item for consideration is H.R. 825, the Banning Operations and Leases with the Illegitimate Venezuelan Act. The clerk will please designate the bill.
H.R. 825, the Banning Operations and Leases